Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to our Curious Amalgam. I'm Jeny Maier, and today's episode is Green the New Black? Greenwashing and Consumer Protection in the Fashion Industry. I'm here with my co-host today, Puja Patel. Hey, Puja.
Hello, Jeny.
Can you introduce our guests for today?
I would be delighted to. So we have two guests here today. First is David Baay, who is a partner in Baker McKenzie's Litigation and Government Enforcement Practice Group, based out of the firm's Houston office. David has over 23 years of trial and arbitration experience and is an extensive speaker on greenwashing and litigation exposure arising from greenwashing claims. Hello, David. Nice to have you.
Good morning, Puja. Thanks for having me. This is great.
We also have Katia Boneva-Desmicht, who heads the Litigation and Arbitration Practice Group at Baker McKenzie's Paris office. Katia is an experienced practitioner in distribution and commercial law, including consumer protection issues. She regularly represents companies from industries including retail and luxury, and she's closely involved in the management of the firm's consumer goods and retail industry group. Welcome, Katia. Nice to have you here.
Thank you very much for the invitation. I'm very pleased to meet you so and discuss these trends.
Excellent. Well, yes, Katia and David, we're really excited to have you here today. I'm looking forward to learning a lot. As an antitrust lawyer myself, I don't get a chance to learn too much about consumer protection. And as a shopper, particularly online, you read a lot of ad copy and see a lot of materials that are promoting goods and clothing that's recycled, eco-friendly, green, water conscious, and other things like that. And what I'd like to know is sort of where do those sorts of claims cross the line, and what kind of risks do those claims pose to companies who are trying to work in that line of business. So with that, I will toss the mic over to Puja to get our conversation started.
Great. David and Katia, could you first just help me set the stage here? Just what is greenwashing? And maybe also if you can provide some examples of cases or investigations you've seen relating to greenwashing, particularly as it relates to the retail and fashion industry.
Certainly, yeah, I'll jump in with that one. And just a basic definition that we use when we refer to greenwashing is an allegation that a company has made a misleading statement about the environmental attributes of its product or service. That's fundamentally what it involves. What we tell our clients who we advise on these issues is it's basically an issue of substantiation. If the claim is made against the company that something they have said that's a public-facing comment can't be substantiated, well, then you're at risk of facing liability for these claims. And just the evolution of these is that there were originally state actions, at least in the United States, where attorney generals would come and file claims against companies for their, mostly in the early days, it was marketing statements. It has since evolved into, sustainability reports and other statements that companies make in their public disclosures. And then the claims have evolved from state actions into now private class action claims. So that's the landscape, at least here in the United States.
What are some of the most common channels of communications that get companies in trouble?
I would say any channel of communications with the public is potentially a risk, because from the displays you've seen on metro station to more personalized advertisement methods in social media, any message, any label, any information that is provided to the public, which outlines the green qualities of a product, but is not substantiated, is basically covered by the legislation, at least in the EU. I would say that probably online advertisement is probably predominant. It is, I would say, the easy one to manage, and if there are any consideration, it could be misleading. But any type of communications is covered.
And David, can you talk a little bit more about the government enforcement activity in the U.S.? How do you see the FTC and its green guides influencing greenwashing enforcement in the industry, particularly the fashion industry?
Yeah. Well, so the green guides, at least from my perspective, provide a very helpful set of rules that we use to counsel our clients. Because if you are following the mandate set down by the green guides, you've gone a long way in protecting yourself against claims. Because on the surface, you can immediately say, well, here is a prominent governmental agency that has put forward some standards about how these statements should look and appear, and we followed those. And then what we also tell our clients is, match those standards and then go above and beyond in how you substantiate. And if you're doing that, again, that's a really solid, strong defense if you face these claims.
Has the FTC put out any updates to the green guides? I understand they may be currently taking a new look at them. Do you anticipate any changes, and how might those changes impact brands?
Yeah, so if memory serves, I think the original green guides came out in 92. The current set of standards is 2012, if I remember correctly. And we've been talking about greenwashing for a long time. And every time we talk about it, we're like, they're just on the verge of publishing new green guides. But we've been saying that for now, 4 or 5 years. So I think people continue to think it's any day. But in the current environment of this administration in the U.S., I think it casts some doubt on when they'll come out, and it really casts doubt on how they'll be enforced. So it's a guessing game as to when new ones will come out.
So moving over to the other side of the Atlantic, Katia, I want to talk a little bit about what's happening in Europe. Can you explain the European Commission's approach to addressing greenwashing activities?
Yeah, sure. The EU Commission has, in a way, a global approach with respect to sustainability by outlining a strategy for sustainable and circular textile products, which is part of what we call the EU Green Deal. There are many actions undertaken on EU level to reduce environmental impacts of fashion products, and it goes from ensuring design requirements to have more long-lasting products to, circularity of the sector, reduction of waste, and ultimately, of course, protection of people from greenwashing. The approach comes really from some findings the Commission did. They really made a main broad study on the EU market, and their finding is that 53% of green claims on the EU basically are too vague, misleading, or unfounded. 40% of those green claims are not even substantiated. And almost half of all green labels used in the EU currently lack really verification. And this led basically the EU Commission to adopting different pieces of legislation. The most important concerning greenwashing are the Empowering Consumers for the Green Transition, what we call the EMPCO Directive. This one was approved in March 2024. It amends the current Unfair Commercial Practices Directive by introducing some specific, sanctions on practices related to greenwashing in particular. And it should be applied by member states by September 2026, because as you know, we have EU legislation and it needs to be implemented in the legislation of member states. And in France, for instance, this legislation is already applicable because some member states could go quicker than others and already apply this piece of legislation. And there is also the EU Green Claims Directive, which was tabled by the European Commission in March 2023. And both directives extend beyond the EU because they would apply to any company that makes voluntary environmental claim directed to EU consumers, which needs to comply. So all this, for example, a US company making an environmental claim directed to the EU market should comply with these requirements. And the idea is really to bridge the gap between the current standards, which are really varying and unclear, to validate basically environmental claims under a more common and clear criteria.
So if you have the EU directives as well as the kind of member state versions of them, how do the sort of guidance for the EU and for the member states compare to the approach taken by the FTC? And do you see any challenges for global fashion brands to comply with both sets of regulations?
Yeah, I think that ultimately on each side of the Atlantic, the goal of this legislation in the US and in the EU is really to increase transparency and reliability of green claims so that the consumers can make decisions based on relevant, comparable information. And at the same time, the aim is also to provide some guidance on criteria that the brands should apply. Probably what the brand should keep in mind is that the EU approach is probably less flexible, I would say, where the FTC would require a reasonable basis for the substantiation of a claim. The Green Claims Directive, for example, sets out a very detailed framework for a methodology you have to apply to substantiate a green claim. The methodology must be based on widely recognized scientific evidence, use accurate information, take into account relevant international standards, should take also into account the entire life cycle of a product. So must weigh also the positive environmental impact against any negative impact, must be also verified and certified by a third party, take into account the scientific progress. So it appears to be much more complex and less flexible, I would say. So obviously it will be important for companies to probably apply the strictest standards possible when they have, products distributed widely worldwide, so that they are sure that, any communications that goes on the EU market, for example, is not below the standards set by the EU.
Maybe let's talk a couple minutes about some investigations in Europe that have made the news. We've seen some news that the Italian Competition Authority is investigating Shine for some allegedly misleading environmental claims, particularly about its so-called Evolushine collection. Can you tell us a little bit about that case and what that signals about scrutiny on fashion brands?
Yeah, I think many of the UK competition authorities, and not only competition authorities, more general, because you have consumer protection authorities, and sometimes authorities specialized in advertisements, really scrutinize very closely the market to detect any greenwashing. So, and many of these EU authorities would like to send a strong message around greenwashing. So the Italian Competition Authority is one example with respect to the environmental claims made by Steen. But there are many others. I mean, the UK competition authorities has also been very active lately, targeting some brands around their, communications on green, aims or goals. In 2022, the DGCCRF, which is the French Consumer and Competition Protection Authority, made an unprecedented investigation into environmental claims, inspecting more than 1,000 companies. And very recently, they even used a temporary notice, publicly enjoining a company to cease making misleading claims, moving towards a form of a, name and shame approach. And what we also see, it's not that much in the fashion industry, but a kind of combined approach of the authorities, because following an alert from the European Consumer Organization, the EU Commission and the EU consumer authorities, so of several countries, sent letters to 20 airlines, for example, identifying several potential types of misleading green claims and asking them to bring their practices in line with EU consumer law within 30 days. So we are not, sure that they would not likely adopt the same approach with respect to other industry sectors. And I would say that even beyond investigation, there is really a willingness to address green claims, and in particular fast fashion. Currently in front of the French Parliament, there is a pending proposal for a law, which is called now the fast fashion law, and which aims to regulate fast fashion through major measures, such as, for example, clearly display messages around, the impact of fast fashion, providing for an additional fees, €5, could be €10, or even 50% of the item retail price, to basically penalize fast fashion, and also prohibit any advertisement on fast fashion items.
Wow, that's some really aggressive action.
It is, yeah.
David, Katia, switching gears to talk a little bit about private litigation in this space. What are some common claims that you're seeing plaintiffs bring in these types of greenwashing cases? And how the heck do these plaintiffs make out damages?
Yeah, that's a great question. We've focused on that a lot in our conversations with clients, the damage question that is. And I'll give you an example of a case that was filed in California against Delta. This has been now a couple of years, but it's a good illustration because it's demonstrates that airlines have been in the crosshairs on these claims, as Katia touched upon in both the EU and the US, in addition to energy companies and fashion companies. But this particular claim alleged that it got a class of plaintiffs together, and the class alleged that had they known that Delta's um, forward-facing environmental attribute comments were not substantiated, they would have purchased tickets on a different, less expensive airline. So they take the delta in their the difference in their ticket price and use that and multiply it over the class. We interestingly I think it was last September in New York, we put on a greenwashing seminar, and we brought in several experts who talked about how they have kind of focused their work now on developing these damage models for greenwashing claims, and to make a complicated issue much less complicated. What they really do, it's evolving to, is put together kind of surveys on how price has changed based on the perception of the marketplace in whatever the alleged misleading claim is. So it's a lot of hypothetical work, which means in the litigation world it's subject to great attack, because it's the damage numbers at least aren't anchored in hard data, and so I think you'll continue to see it evolve and gain more acceptance. But early days, these damage models have been attacked pretty fiercely.
Has there been kind of a development in the case law adjudicating these claims, specifically in the greenwashing area, or do you see the case law as it applies to sort of, deceptive advertising more generally applying here? Is there a sort of growing robustness in the case law, or do these claims tend to get settled?
They very much tend to get settled and dismissed. The early wave of greenwashing claims, even the Allbird case that I mentioned, got dismissed ultimately. So it's hard to find case law that gives any great insight into it. The interesting thing is that these claims fundamentally tie back to really old deceptive trade practice statutes that have been around for a long, long time, and they've just been co-opted for these greenwashing claims to fundamentally say that a company is issuing misleading statements in their advertising. Of course, it's the other development is, as companies, like any sophisticated company, if you go research them, has a long and lengthy sustainability report that they put onto the internet. Even law firms do it. You can go see the Baker McKenzie sustainability report. Those types of reports, we have noticed, provide, even or most especially for the big energy companies, provide a lot of ammunition for these private plaintiffs to go and pick apart the statements to see if the data is there to support them.
And how have companies responded to these new either consumer actions or other class actions? What kind of activities have you seen clients undertake in order to mitigate risk?
Yeah, interested in Katya's answer on this one, but what I've seen is, for most of the sophisticated companies and even smaller, not publicly listed companies, they're developing ESG departments, positions within the legal team, within the C-suite, people who have sole responsibility for paying attention to these kind of statements and the public-facing comments that companies are making. And you see it more and more, and it's why it ties to my comments about why you have these sustainability reports. The more a company can show that that's very serious, it's taking this issue very seriously, and that its higher management is paying attention to it, those are the ways, those are more of the ways that you can defend these claims.
Yeah, I agree completely with you, David. I think that beyond the threat of legal claim on investigations, the brands are particularly careful to preserve their reputation, and it's even more true in the fashion industry, where the brand is really the core asset of the company. So any negative publicity could have enormous impact, and the brands are really investing in these ESG teams, which are very well integrated. I mean, they are in contact with all the other teams within the company, so that they can, proactively promote the message that, any broad claims should be avoided, that, anything that it's included in a marketing material should be substantiated very carefully. And, the transparency is really, I would say, the word that now leads their marketing policies.
David, Katia, what are your predictions for the future enforcement activity in this space, particularly in the US, where we have a new administration and lots of things have been changing and reprioritized here?
Yeah, so I touched on that briefly in my opening comments, but I think that the conventional wisdom is that the enforcement actions from the federal government and state governments will greatly decrease. Just take, for example, standing alone, the SEC disclosure rules that have been issued, 2 or 3 years ago. The prediction was that those would be the source of a huge volume of enforcement actions. In fact, the SEC even put together what they called an enforcement team in anticipation of those rules. That team, as I understand it, has since been disbanded. And from what you read, if you believe what you read in the newspaper, there's absolutely no priority given to the SEC chasing these kind of claims anymore. So I think that if we're just talking about enforcement actions, they're going to decrease. I think but we think that the private class action claims will maintain same levels, or if not increase, because you have these firms who commit to the model and they're off and running and they sustain it for year after year.
Yes, I agree with you, David. I mean, it's difficult really to predict the future. I would say even now, I would love to have a crystal ball and be able to see what will happen tomorrow. We do see from the EU perspective, we do see what's happening in the US. We see that there is some kind of deregulation approach being taken by the US authorities. I'm not sure that the EU will follow that way. For sure, what we observe, however, is that the EU Commission is trying now to simplify the ESG-related legislation. Some of the directives applicable on reporting obligations, and in particular the thresholds for the applications of that legislation, are currently being reviewed by the EU Commission. So we will certainly keep a very strong ESG legislation, but it will be probably to some extent a little bit simpler to apply to what was initially conceived by the EU Commission. And I think this is probably under the influence of the US, and precisely with the aim of preserving the competitiveness of the EU companies as well. And I think the big question would be around the interaction between the different legal landscapes, and probably the question around sanctions and counter sanctions. I would not say the word tariff, which is now obviously the main focus for many of the companies in this sector, but where there would be a risk for companies complying with, for example, EU legislation being sanctioned, or is there a risk of counter sanctions in the US for the EU imposing, strong ESG regulations? I'm really curious to see what will happen in the future. For instance, what we are seeing now is that, for example, China is adopting some sanctions by creating, for example, a list of unreliable entities for any companies, US and EU companies, complying with US and EU ESG regulation, in particular on forced labor. So I'm really curious to see if such approach could be also taken in the US-EU relationship.
Wow, that's really interesting, especially to see how the kind of global impact on how these regulations are crisscrossing and having ramifications on one another. I had one more question for you, David. At the beginning, you mentioned state AGs, and with the federal government, perhaps in the new administration, dialing back enforcement as it relates to environmental claims or other sustainability claims. Do you see any states still prioritizing this that may be sort of going it in a different direction from the federal government?
Yeah, absolutely. Good question. I mean, the ones who were at the forefront, the states that were at the forefront of making these claims was really California and New York. I think everybody would agree that California will continue to be at the forefront of making these claims. In fact, they passed the most statutes that are greenwashing focused of any state. I think that's fair to say, easy to say. And so I think those two will definitely be at the forefront.
Great. Well, this has been a really fascinating conversation, and I am learning a lot from you guys, and I wanted to thank you very much for being with us here today. And in order to segue, if you have heard this podcast before, we like to get to know our guests a little bit better on a personal level. And one of the questions that we ask all of our guests is to tell us something about yourself that we wouldn't know if we only knew you professionally. So starting with you, Katia, tell us about yourself.
Well, probably one of my dream job, and it's really related to the session we have today. One of my dream job when I was a kid was to become a fashion designer. So when I was in high school, I was kind of created a collection of dresses from paper and plastic and organized a fashion show with some of my classmates. So now when I think about it, I was kind of a pioneer in sustainable fashion.
Fantastic. What about you, David?
Well, that's a hard one to follow, but most people learn about me quickly once we stop talking about work that I have 4 boys, most of whom are college age. So my wife and I spend most of our springs and falls at parents' weekends at various schools, which is a real joy into our life. And my 3rd son is about to go play baseball at a small school up in the north called Middlebury. So we're getting our frequent flyer miles out and our warm coats to go watch some cold baseball.
Well, thank you both for that. We also, so if you've listened to the podcast, we also like to ask our guests a random question about their personal lives that you were not expecting, called the Curious Hat.
And now it's time for the Curious Hat.
So, question to each of you: if you were given $50,000 on the condition that you spend it all in 1 hour, what would you buy?
All in 1 hour. Oh, that's difficult. Probably a plane ticket to make, a trip around the world and, discover various cultures, I think. Book a
David,
trip
what about
around
you?
the
Are
world.
you going to see your kids in college?
Yes, I'd probably put some of that on airplane tickets and tuition. But our office just went and served at a place called the Ronald McDonald House here in Houston, which provides housing for families with sick children. Houston has a huge medical center, and it was the most uplifting place I've ever been. So I'd give a big chunk of it to the Ronald McDonald House here.
No, that's
Excellent.
Well, thank you both for joining us today on our podcast, telling our audience a little bit about these greenwashing claims. I personally learned a lot, and hope you guys both have a great day. Thank you to the audience.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.